Hello, we are here today again in order to talk a little more about the Brazilian legal system. And today we are going to discuss, we are going to show you about the legislative process, specifically the role of the President of the Republic. Let's start it. So, our intention is to talk about how the laws are making here in Brazil. Who are the players? Who is the most important player, let's say in this way? And to talk a little more specifically about the role of the President of the Republic. Well, the Brazilian Federal Constitution assigns to the President a broad role in the drafting of laws, normative acts. The chief executive has a broad participation in the federal legislative process. I mean, the series of acts that are aimed to transform bills into statutes, laws that will govern with greater or lesser extent the relationship among people, companies, and the state. Although the participation of the President is quite significant in the Brazilian legislative process, any bill that integrates this process must be presented before the legislative branch. It means that the most important and indispensable player is the legislative body itself. Well, let me explain better. I mean, the President of the Republic, as I said before, has a very important role, as we will see in the following minutes. But, for sure, the indispensable player, the indispensable power in this phenomenon, in the way to make laws, is the legislative body itself. Well, this phenomenon of active and extensive role of the executive power in the legislative process is also observed in the states, because as you know, Brazil is a federation. So we have states, we have municipalities, and we have the union, the federal government. As I said, this phenomenon is also observed in the states, where governors play similar role as the president. The mayors in the municipalities, we have here in Brazil 5,000, almost 5,500 municipalities throughout the country. So the mayors also have an important role in the legislative process, although with somewhat smaller number of powers than the President of the Republic and the governors. By the way, the states, the municipalities, and the federal district form our indissoluble federative republic. Our federation, as I mentioned in a previous lesson, was inspired by the American model and was adopted by our first Republican Constitution of 1891. Let me make a little comment here about our constitutional history that we have did before, but just to remember that the first Brazilian Constitution was a monarchical one in 1824, based influenced heavily by the French model. But our first Republican Constitution was from the 1891. Well, but there are several, I was talking about similarities between Brazil and the United States about the federative system of states. So there are several differences between the Brazilian federative system and the United States model introduced by the 1787 Federal Constitution. Well, let's see the legislative initiative of the President of the Republic. Well, the legislative process, as any process, is made by a series of acts. The first step is the legitimacy to start it officially. We call it here in Brazil as the legislative initiative, as the Constitution deals. The Constitution, mention this expression, legislative initiative, which means the constitutional authorization to present a bill or to propose a constitutional amendment before the National Congress. The National Congress here in Brazil comprises two houses, the House of Representatives, that we call here Chamber of Deputies, and the Senate. Well, in Brazil, the President of the Republic has legislative initiative on almost every law and every subject, such as civil, criminal, commercial, except when the Constitution states that the issue belongs exclusively to the House of Representatives or to the Senate or to both together, simultaneously to both houses. For example, to deal with the internal affairs, the House of Representatives. Just the House of Representatives has the legislative initiative to initiate a bill, a proposal that deals with the internal affairs, the internal organization. Well, the President also cannot propose a bill concerned to the organization of the judiciary power and about the prosecution offices. Only they themselves can propose it. It's very interesting here in Brazil. I'm not sure if another country confers to the judiciary the power to initiate a bill. And here in Brazil, the judiciary and the prosecution office has legislative initiative about some specific subject concerning themselves. Well, let's go to the third part of our lesson today. That is about the urgent request. That's a very interesting instrument, power of the President in the legislative process. Urgent request. Okay? Well, what is the urgent request? As I said, it's very interesting. The President of the Republic, the Chief of the Executive Office, beyond the ordinary legislative initiative that fits both him and any representative or senator, has exclusive legislative initiative in some matters. This means that concerning subject, he has sole initiative. Only he may propose a specific bill before Parliament. Okay? Article 61 of the Federal Constitution of 1988. Let me give an example. Creation of public offices, creation and the structuring and duties of the ministries and public administration agencies, among others. But another important prerogative of the president that what I mentioned before, a little before, is to request to Congress the urgency in examining the bill of his own initiative, Article 64, paragraph 1. Well, let's see it here. I think that I can find it here in the Constitution, Article 64. I will read for you paragraph 1. Let's see the caput of the Article 64. The discussion and voting of the bills of laws which are the initiative of the President of the Republic, the Supreme Federal Court, and of the Superior Court shall start in the Chamber of Deputies. Chamber of Deputies is the same of House of Representatives. But let's see now the urgent request that I mentioned a little before. Paragraph 1. The President of the Republic may request urgency in the examination of bills of his own initiative. Well, as I mentioned, the President has initiative about some subjects, okay? And the subject, the bills that he has the initiative, he has also the power, he has also the prerogative to request, to make an urgent request that he made before the Parliament, before the National Congress, or before the House of Representatives. Why he should do that? Why he will do that? He would do that, better say, if the subject is very important and he has to decide, and he would like to have the bill approved in an urgent way. So he will sign a kind of memo, something like that, directing to the Congress, before the Congress, requesting the urgent appreciation, the urgent request. Well, that's it. We are going to see now 3 different subjects concerning the prerogative of the President in the legislative process. We are going to discuss the provisional measure, that's very interesting, very polemic. We are going to see the requirement and duration of the provisional measure, requirements and duration of the provisional measure, and also the first discussion and vote. First discussion and vote of the provisional measure. I put 4, 4.1 and 4.2 because they are all linked to the same subject. Well, let's start with the provisional measure. That's a very interesting, as I said, it's a very important tool, a very important, here in Brazil we say instrument, but a professor in United States said to me one day that instrument is not very common to use as a prerogative in the English language. But let's see the provisional measure. Okay? What's the provisional measure? Among the powers granted to the President by the Constitution, the provisional measure is, without doubt, the most important and controversial one. It was created by the Federal Constitution of 1988, established in the Article 62. I said that it was created by the Federal Constitution. Yes, it was. With this name, because in the past we have something very close to the provisional measure, that was the law decree. It doesn't exist anymore. It was in the time of the military dictatorship. Well, no other authority except the President of the Republic can adopt it. Just him, just the President can adopt the provisional measure. Just him. The provisional measure takes effect immediately, even before being considered by the legislature. Well, requirement and duration. The Federal Constitution says that the provisional measure can only be adopted in case of urgency and relevance. Urgency and relevance. Let's put here to be better understand. Relevance. Okay, that's the first prerequisite, and urgency. That's the requirement. The President of the Republic can only adopt a provisional measure if there is two requirements. Relevance, the subject is relevance, and the subject is also urgency. Urgent. Okay? Not urgency, urgent. Okay? Both must be present simultaneously. The President cannot adopt a provisional measure because the subject is relevant. No. Both requirements must be present simultaneously. Okay? The day the President adopts it, she must submit the provisional measure to the National Congress, which has 60 days. 60 days, that the duration, okay? 60 days to discuss it. The Congress has 60 days to approve or not. If the National Congress does not approve, there is an extension of additional 60 days. So an extension, okay? An extension of 60 more days. So in total, a provisional measure, can be discussed in the Congress for 120 days. Okay? If Congress approved it, the provisional measure becomes law. Once it was provisional, if the Congress approved it, it becomes law. A statute. If it does not, the provisional measure ceases to exist. It disappeared. Okay? So the Congress can do both things: approve or not approve it. Okay? Well, first discussion and vote. When the President adopts a provisional measure, she must submit to the National Congress, as I said before, with the House of Representatives beginning the discussion. The discussion does not begin in the Senate. It begins in the House of Representatives. And then, if the House of Representatives approves it, the provisional measure goes to the Senate. Okay? Well, let's continue with another subject concerning the provisional measure. That is an exclusively prerogative of the President of the Republic in the legislative process. Let's see, modification of previous legislation. Modification of previous legislation. Then we have examples. Let's see an example. In fact, just one example. And then let's see the principle of presumption of constitutionality of law. Principle of presumption of laws, and then material limitation and provisional, and then the 45th day rule. The 45th day rule. Let's start with that. Modification of previous legislation. The provisional measure has the power of law. Once it is published, the provisional measure immediately overrides an existing and previous legislation that is contrary to its text. Example, the National Traffic Code, we have here the National Traffic Code, provides that, here in Brazil, provides that only those over 18 can obtain a driver's license. Only those over 18 can take the test in order to obtain the license to drive. It is a statute, a national law enforced throughout the country. It's different than the US, where in the United States you have a law that is local, it is a state law that deals with subject. Here in Brazil we have a national law. Most of our laws are national, concerning about the civil and criminal law are national laws. Because it is a law, of course, as we know from the constitutional theory, only another law of equal or higher hierarchy can modify it. The provisional measure, as it has the force of law, may amend this rule by establishing, for example, that the minimum age is 16 or 21 years. Okay? What I am trying to say that the provisional measure, even though it is provisional, it can modify an existing law, as I mentioned, the National Traffic Code. Okay? The provisional measure, however, will always be provisional, effective just for 60 days, renewable for another 60 plus 60. It will become law only when approved by the legislative body, only when approved by both houses of Congress. Principle of presumption of constitutionality of laws. Okay? Here, 4.5. The provisional measure is born with a presumption of constitutionality, as all other laws. I mean, when a law is born, it's presumptive that it is in accordance, it is in harmony with the Constitution. So, with the provisional measure. The temporary is not like to depart immediately that presumption. Well, material limitation to the provisional measure. Constitutional Amendment 32 from 2001 established some limits on editing the provisional measure. It hasn't before, okay? Which did not exist in the original text of Article 62 of the Federal Constitution. In summary, provisional measure cannot handle with some topics, among them the organization of the judiciary, the organization of the prosecution offices. A provisional measure cannot deal with tax, for example. A provisional measure cannot deal with criminal law, and among other topics. Well, let's see now the 4/5 day rule. If the provisional measure has not been approved by the National Congress after the 4/5 day from the date that it has been issued, Congress cannot vote for anything, any other bill, any amendment, any constitutional amendment, until it finishes the discussion of the pending provisional measure. This is a way that the legislator found in order to demand the Congress to vote the provisional measure, and does not postpone it indefinitely, as such case has happened in the past. People, listen the soundtrack here in Brazil. I don't know if you will listen. We have the birds outside the classroom. They are singing for us, okay? I hope you listen. Well, let's see now the approbation 4.8. Well, let's see. Let's continue with the provisional measure. We see the 4/5 day rule. Let's see now the approbation. Well, with the approval, the approval of the Congress, the provisional measure becomes law, ceases to be temporary and becomes permanent. On the other hand, if Congress rejects it, it is no longer enforced. There is no longer anymore. Okay, that we call, using a Latin word, if provisional measure is rejected, it loses, it ceases to affect its effect. The effect is extinct. Well, rejection of provisional measure effects. What happens if the Congress rejects a provisional measure? The Constitution says that Congress itself must regulate by a legislative decree the effects taken during the time that the provisional measure was valid. And provisional measure in the states members. The Federal Constitution of 1988 does not authorize nor prohibit a state from adopting a provisional measure. On this matter, the Supreme Court ruled that the state governors can adopt it once authorized by the state constitution. Let me explain better. The Federal Constitution of 1988, okay? Federal Constitution of 1988 does not prohibit the states to have provisional measure. But the Supreme Court said in a decision, ruled that the states can adopt it, since the state constitution authorized the governor to adopt it in the state territory. That's it for today. I want to say thank you for your attention. I hope that you enjoy our meeting today, that we talked about a very important issue that is the Brazilian legislative process and the role of the President of the Republic in the legislative process. Thank you very much. Bye-bye.